pleading guilty to breaking and entering, a felony that carries up to 12 months in prison and a maximum fine of $2,500. State's dismissing count 2. Have I stated that correctly, Mr. Goodyear?
Yes, Your Honor.
Ms. Van Gundy?
Yes, Your Honor.
Mr. Schultz, do you understand the nature of the plea here?
Yes.
I want to go over your rights. You're presumed innocent of these charges. You do have a right to have a trial. Can you tell me what the allegations are?
Judge, this is where there's the victim's barn sits on a piece of property. The defendant was in the process of having been in the barn and then trying to take property. There was a ladder that was placed to allow entry into it. He's captured on camera being there. He's found hiding in a creek afterwards by the police wearing the exact clothing that he's wearing in the video where he went in to steal property, and ultimately was found and arrested by the police in the area.
Well, here's the thing. If he wants to force it to trial because he thinks there's a speedy trial issue, it's not a good decision because we will have a trial.
I understand, Your Honor.
And if he's convicted, he'll regret that.
I understand, Your Honor.
He was here with the plea, ready to go forward with the plea. I told him he had a right to a trial. He has a right to a trial. We will make time. If we have to get another prosecutor who's more flexible with their schedule, then we'll do that. But speedy trial statute doesn't say if a prosecutor is available, you can have a speedy trial, but if it's not, you can't. So we'll work it out. Let's just get the next available date. You're saying what date you're available?
Your Honor, you know what? I'll take the plea.
Okay, I have a plea right here. Is that what you want to do?
Yes.
Okay, I've been over your constitutional rights with you. What is your plea to breaking and entering?
Guilty.
Did you commit the offense? That's what you're admitting.
Yes.
Okay.
Buckle up, guys. Today we're going to witness a courtroom moment where a burglary case takes an unexpected turn. What begins as a routine plea hearing quickly becomes tense when the judge lays out the prosecution's evidence, including surveillance footage and the defendant's arrest. Then comes a major warning. Rejecting the plea could lead to trial and a much harsher outcome. Faced with that reality, the defendant makes a decision that completely changes the direction of the case by pleading guilty.
I accept your plea, make a finding of guilty. Order a pre-sentence investigation. Also order an evaluation to determine if he's eligible to spend any portion of his sentence in a community-based correctional facility. Is there anything else you want to address, Ms. Van Gundy?
No, Your Honor.
Did you want to address bond? I can tell you wanted to say something. What is it you want to say?
I was just curious about the address. You know, if I was placed on probation, you know, I've had a hard time verifying an address to go to. And my attorney had said something about the Hope House or something along them lines, or?
That might be an option.
Okay.
Anything on bond?
Judge, if you recall, we just had a bond hearing 9 days ago.
I do.
And we had a full discussion about all this. The victim gave a statement. He's failed to appear previously in this case while on a monitor, and the court made the decision to maintain his bond. I think that's an appropriate decision. He's now been convicted, and I think that certainly when we come back for sentencing, if the court chooses not to incarcerate him, then he will have the opportunity to possibly go to some type of location where he'd be released. But at this point, Judge, as I said, nothing has changed whatsoever since the last time we had a bond hearing, except for now he's been found guilty.
Tell me why you think something's changed. You didn't show up the last time.
Well, my van was down. You know, it's a big part of the whole reason.
All right, guys, the guilty plea may be over, but the courtroom drama is just getting started. Now, the focus shifts to the defendant's future as he asks about probation and requests another chance at bond. The prosecutor strongly pushes back, reminding the judge about the defendant's previous failure to appear in court. In response, the defendant offers an emotional explanation, insisting transportation problems, not intent, kept him away and promising he has learned from his mistake.
I'm sorry, Mayor, but the victim would also like to be heard on bond as well.
Okay.
Your Honor, I'm Helena Cable. I'm not sure you've seen
Are
me
you the
before.
owner of the property?
I'm sorry?
Are you the owner of the
My
property?
father's the owner of the property. I'm with my father. My father's 85 years old and can't hardly walk.
Okay, go ahead.
He's lying. He was here the day of court. I saw him here in a Mercedes. I've got pictures of it. He went down to Clarksville. I called the police. He was down at a trailer in
I'm
Clarksville.
sorry, ma'am. Can you slow down just a little?
I'm sorry.
You went
I
to
apologize. He went to Clarksville after he left here, but when he saw me, he chose to leave. We were both here early. We were the only two cars in the parking lot of the other location. And as I've stated before many times, these guys keep breaking into us. We've got 22 outbuildings. And as much as you stated, post those things up, I would like the word to get out as much as it was. We have the equipment there that we do, that you know what, we're going to prosecute each and every one of them. Because this has cost us quite a bit of money. And
All right, guys, this is where emotions take center stage. The victim's representative steps forward and directly challenges the defendant's story, claiming he deliberately skipped court, and even presenting details that paint a very different picture. The courtroom shifts from legal arguments to questions of credibility, while the victim describes repeated break-ins that have taken a heavy toll on the family. Now the judge must decide who appears more believable before making his next move.
That's the issue, is will he show up for court? If he doesn't, then he'll go to prison for 12 months. That's the max I can give him. But if he does, then there's a presumption of probation on this case. I haven't looked at his record. I don't know all the other factors, and I don't want to make a decision before that time. So, I'm going to release you if you are admitted to the Hope House on a monitor. And you seem like you don't have a problem understanding. You better understand this.
All right, guys, everything now comes down to the judge's final decision. After weighing the arguments from both sides, he delivers one last warning that could determine the defendant's future. Instead of immediate prison, the court grants a conditional release with strict electronic monitoring, making it crystal clear that one more mistake could lead straight to a year behind bars. If you enjoyed this courtroom breakdown, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss our next case. Thanks for watching, and we'll see you in the next video.